Good evening, everyone, ladies and gentlemen. Thank you very much for attending this presentation here at our office in Shanghai, as well to all our participants online. The topic of today will be, I think, interesting for everyone because I think, never have enough knowledge regarding compliance. And today we have the chance, and thank you again to Andrea Buchin and her team, to DS Avocat law firm, to give us tonight an update and as well a reminder regarding what every executive, not only the legal representative of every company, could face off in case of non-compliance. And regarding everyone regarding the personal liabilities in China. So without further ado, Andrea, the floor is yours.
Good evening, everybody. I'm going to make it short. Yes, executive liability, it's a good topic. It should be also a scary one. Our, our idea tonight is to share with you, with the seventh speaker, our knowledge and also our experience. But more than that is to try to show you that compliance can be, at the end, the best way to avoid such difficulties on your daily or on your work in China. So let me introduce our team, a part of our team. Young Lily, she associate and specialist in corporate law and M&A. Wu Yan, partner and also specialist in corporate, in distribution contract and M&A also. CC, associate, corporate and medical regulation. Liu Min, senior associate. That is terrible. M&A, work safety and environment. Zhang Beibei, associate, corporate, and I will not say the word MTM or something. It's impossible. So it is data compliance and also cybersecurity. Liu Yijun, tax and customs specialist. And the last but not least, Colleen, that is in charge of corporate and all new technology. So I like.
Okay, thank you, Andrea, for the introduction. So today we will be talking about the executives' personal liability in China. And actually, this is one of those questions that we are most asked by our clients in the past many years. So it's indeed a true concern. And they all wonder, like, in what kind of circumstances that they might be found liable for managing a company in China and what would be the consequences. So sorry. Okay. So today, I will first give you a brief introduction on those general rules for these liabilities, and then my colleagues will each give you more details in those specific area of law, such as bankruptcy and anti-bribery, environment, data protection, tax, and also judicial enforcement. So first of all, the executives that we will be talking about today should refer to the directors, senior management, such as the CEO and CFO, and also as well as the legal representative. And in China, the legal representative is also the director or the general manager. And the liabilities that the executives may assume personally include the civil, administrative, and criminal. So first of all, for the civil liability, the general rule is that if the executives if the executives breach law or article of associations of the company in the course of performing his or her duties, and then he should be personally liable for the damages caused to the company. So in other words, if the executives breach his duties or to the company, then he should be liable. So the PRC company law has specified two kind of liability, two kind of duties that the executives owe to the company. One is diligence duty, and the other is loyalty duty. So the diligence duty usually refer to the acting with reasonable care, skill, and diligence. Such as if you are a director, you should attend the board meeting actively, and you should judge with prudence. And it's also well worthy to be noted that according to some court opinions, a director's diligence duty should also include a duty to urge the shareholder to pay in the capital. And actually, there's a case where the directors failed to urge the shareholder to pay in the capital, and then the company went bankrupt. And in the end, the Supreme Court held that the directors should be liable for the damages caused to the company, which almost equal to the amount of the capital that is unpaid. So the loyalty duty usually refers to the acting in favor of the company's interest over the executive's own interest. So such as not misappropriating the company's fund, and not self-dealing, and also not carrying out the competing business with the company. This is for the civil liability. And for the administrative liability, such liability will be imposed on the executives if the company breaches law, and if the executives are held to be the liable person. So in other words, the executives will not automatically be held liable for the wrongdoings of the company unless he is found out to be the liable person. Such liable person includes a directly responsible person in charge, and also other directly responsible persons. Unfortunately, there's no law that gave definitions for such the scope of the liable person, but rather it's in the specific area of law. The government will give some opinions on guiding the scope of the liable person. So for example, in the food safety regulation, the directly responsible person in charge usually refer to the persons who decide, approve, authorize, indulge, or comment the illegal activities of the company. And also, in this case, it's usually would be the head of the company or the head of a department. And then the other directly responsible persons should refer to those people that play an important role in carrying out the specific illegal activities. And this can be very broad, can extend to just like a normal employee of a company. So, and then the liability, the administrative liabilities include a fine, detention, and disqualification. So for example, in any non-compliance in manufacturing cosmetic products, the liable person will be imposed the fine up to 3 times of the income that he made from the company in the previous year. And as well as the disqualification refers to that he might be banned from entering the same industry in almost 10 years in his future career. So this is for administrative liability. And then for criminal liability, the general rule is quite similar to administrative liability, that in the sense that such a criminal liability will be imposed only in case that the company commits the crime, and then also the executives is found out to be the liable person. And the liabilities include fine, detention, and imprisonment. So here I give you some examples about some typical company crimes that were with penalty that will be extended to the liable person, such as like money laundering, that would be end up with an imprisonment on the liable person up to 10 years, and also infringement on personal information that might result in an imprisonment on the liable person up to 7 years. So these are the basic general rules for the 3 liabilities. And in addition to these 3 liabilities, there will be also some compulsory measures that might be imposed on the executives, such as restriction on departing from China, or like a limitation on some high-level consumption. So my colleagues will give you more details on this in this specific area of laws. And so that's basically for my introduction part. And my colleagues Wu Yan will give you more details regarding the bankruptcy topic.
So thank you, Lily. So let's start with the liabilities of the corporate executives for the company's voluntary dissolution or bankruptcy, which can be divided into 2 categories. One is about their legal duties in such a procedure. The second is about their liabilities that may be pursued as a result of the bankruptcy. So let's take a look at the voluntary dissolution first. When the shareholders decide to close a company whose assets are sufficient to settle all the debts of the company, then the company can go through a voluntary dissolution procedure led by a liquidation committee. The members of the liquidation committee are appointed by the shareholders, and the legal representative of the company is in general the responsible person in the liquidation committee. The main duties of the liquidation committee include to notify the creditors, to settle the outstanding tax payment, to recover the credit, and to represent the company in all civil litigations. And if any member of the liquidation committee violates its duties when carrying out the liquidation work, for example, failure to notify the creditors in due time or implement a liquidation plan without getting the approval from the shareholders, and thus cause losses to the company or to the shareholders or to the creditors, then this member shall bear the liability of the compensation. Then let's go to the bankruptcy procedure. In China, the bankruptcy proceeding is led by an administrator appointed by the People's Court. However, the legal representative of the company, the CFO, and other responsible persons should provide its cooperation for the smooth conduct of such proceeding. And such cooperation include attending to the creditors' meeting, answering questions from the court and the administrator. And most important is that they should not leave the place of residence without getting the approval from the People's Court. If any member violates these obligations, for example, leaving the place without getting the consent from the People's Court, then the People's Court can issue a notification of admonishment on him, detain the person, and impose a fine. And if such behavior causes loss to the creditors of the company, then the person shall also bear the liability of compensation. The above is about the legal duties in such a procedure. Then I would like to talk about the personal liabilities that may be pursued against the executives as a result of the bankruptcy. So firstly, as Lily said, because all the corporate executives have to fulfill its diligence duties and loyalty duties towards the company. So if they are in breach of such duties and which cause the bankruptcy of the company, then surely the person should bear the liability of compensation. And in addition, this person shall not act as the director or supervisor or senior management personnel of any other company within 3 years after the bankruptcy termination date. Take an example. in a lawsuit, the legal representative of a company, which is at the same time the executive director of the company, decided to provide a guarantee in the name of the company for the benefit of a third party, which is not commercially reasonable. And then the company went bankruptcy when the creditor exercised this right. When the bankruptcy proceeding starts, the administrator filed a lawsuit against the legal representative, and this person is sentenced to compensate all the economic losses of the company. So secondly, during the bankruptcy procedure, if the administrator finds out some previous misconduct of any corporate executive which had caused some losses to the company, the administrator can also take this occasion to sue to the court and ask the compensation. And in this way, the assets of the company in bankruptcy can be increased and the losses of the creditors can be mitigated. So in addition, if the administrator finds out some intentional misconduct or gross negligence of any executive in the acts when dealing with company's assets, for example, transactions at clear unreasonable price or waiver of creditor rights or prepayment of any debt which is not due or transfer of assets for the purpose of debt evasion, then the administrator can also file a lawsuit to the court and ask the compensation from these executives. So for my part, in conclusion, in a voluntary dissolution or bankruptcy of a company, apart from the legal duties to be assumed by the executives, in particular the legal representative, because of their title in the company, most liabilities come from the intentional misconduct or gross negligence of these executives themselves. So that's all for my part, and I will give floor to Cici, who will talk about the commercial crime.
Thanks again to Ian for sharing with us the personal liabilities of corporate executives during the dissolution and the bankruptcy process, which can be the end process of a company. But does it mean like the executives can be carefree before the end process? So in China, we have a saying like, if you walk along the riverbank, you can easily get wet. Let's take a few minutes and talk a little bit about the riverbank in the daily operations, the commercial bribery. So what is commercial bribery? How is a company regulated? Does the liabilities extend to the management, him or herself? And what can we do to comply? So first, let's talk about what is commercial bribery. The Chinese laws regulates the commercial bribery on two levels: administrative level and the criminal level. On the administrative level, the PRC anti-unfair competition law prohibits a company to offer money or other means to someone in exchange for business opportunities or for competitive edge. That someone, to be specific, can be an employee of the other company, a third-party sales agent, or just someone who can influence the business decisions. So the scope can be quite broad. And the PRC laws also provide, like, if a company offers a discount or offers a commission fees to another company, then such discount and such commission fees shall be truthfully recorded in book. The general rule under the competition law is that it is generally regarded as a misconduct of the company instead of a misconduct of the employee. And if the governing authority, the local EMR, finds it a misconduct of the company, administrative penalties of the company will be imposed as follows. For example, the forfeit of the legal proceeds, the administrative fine between RMB 100,000 and RMB 3 million, a revocation of business license in serious cases, and the company will be included in the credit record, and in serious cases, it will be included in the national blacklist. So far we haven't talked about any personal liabilities of executives, but does the executives just get away with it? Actually, in fact, the legal representative, if the company has been revoked of its business license, and if such legal representative is held personally liable, then he or she will be prohibited from acting as director, supervisor, or senior management for 3 years, starting from the revocation of the business license. The law also provides an exemption. The law also provides an exception, like if a company can prove this is just a misconduct of the employee, the company knows nothing and has nothing to do with it, then it will be regarded as a misconduct of the employee, and such bribery will not go to the company level. The company will not be held liable, and the executives can get away with it. Sorry about that. And what about criminal laws? Actually, the PRC criminal laws just supervise the commercial bribery quite similarly. The general rule is that it will, the general rule is that if such misconduct is conducted in the name of a company, and if the company is the ultimate beneficiary of such illegal gains, then normally it will be regarded as a crime of a company. The company will be imposed of a fine, and the liable persons, as defined by my colleague Lily earlier, will be imposed of detention or imprisonment, a fine, and a confiscation of property, of his or her personal property in particularly serious cases. A famous case in this regard would be GSK, the famous UK pharmaceutical giant. The company bribed in the way of, for example, organizing seminars, sponsoring seminars, offering receptions, offering free travels to hospitals, to doctors, to medical representatives, to government officers, and medical funds in exchange for them to use to prescribe and to purchase the GSK product. The company was found guilty and then was fined for over 3 billion RMB, and the general manager, the chairman, the sales director, the marketing director, and the HR director, they were all sentenced to prison between 2 to 4 years. The general manager and the chairman, as a foreign citizen, was expelled from China after serving his time in prison. So the Chinese law just show no mercy in that. And quite recently, we just noticed like the authorities have been targeting certain areas in terms of commercial bribery. For example, pharmaceuticals, engineering, government procurement, and also retail. So companies in those areas should be extremely careful about it. Having said that, what can we do to comply? We have prepared a checkbox for your quick self-examination. So, do you have an internal control committee in your company? Do you have an employee handbook in place? Have you arranged any compliance trainings for your employees? Is there any reception policy, any gift declaration policy, any conflict of interest rules in your company? Do you have a strict internal accounting and audit system? Is there any compliant and reporting channel? Is there any internal top to bottom anti-bribery supervisions? And last but not least is, have you arranged any audit for your business partners, including but not limited to your supplier, your client, your third party, your agent, your distributor, your dealer? This is just a non-exclusive checklist. And of course, the real business world can be much more trickier than just a few check boxes. So if you find yourself at any time hesitating about any of your business decisions and you feel like you might get white over the river bank, just don't hesitate to call your lawyer, and we as your lawyer, we can help to build that safety net for you. We can help to build that firewall for not only for you, but also for your company. So that's all for me. Thank you.
Thank you for CC. Thank you, CC, for the very informative and interesting introduction of commercial bribery. Now I will talk about the environmental and work safety. One question I'm often asked by corporate executives is, should I be worried about my personal liability that's of my company while I'm managing a company? They often assume that it should be the company who violates the law, and the corporate structure should protect them. That is one of the reasons why company exists. And also, in Western's mind, that China don't attach much importance to environmental protection as well as work safety. That's why a lot of businessmen try to partnership with Asia country in order to avoid the strict regulations that is very commonplace in North America and Europe. China's environmental law dated back to 1987. But many people think that our environmental law enforcement was mostly ineffective due to the weak monitoring and low penalties. We often hear businessmen say that paying fine can be cheaper than cleaning up in China. So the work safety enforcement face the same issue. But things have changed. In 2014, China authorities have declared war on pollution. Ever since then, Chinese authorities have strengthened regulation and tried to put more pressure on corporate executives. So now it's made very clear that under certain scenario, corporate executive can be personally liable. So who will be concerned among all the corporate executives? Our judicial interpretations say that if a corporate executive has a decision-making power or could stop the wrongdoings, he might be personally liable. So the test will be whether such executive is actively, knowingly involved in all the action or inaction. So in practice, an executive at any level can be held personally liable. So it can be like a legal representative, directors, board chairman, HSE manager, or finance manager. This is a chart that illustrates all the environmental crimes in 2014, right before the pandemic, because at that time everything is normal.
So as we can see that among all the 1,380 cases, 19% involve entity crime. And among these entity crime, 66 people are legal representative and 31 are general manager. So as we can see, general manager and the legal representative are identified as the highest proportion, which is maybe related to the fact that, say, most of the time they participate in the management and operation of the company, and they have the decision-making power, or they adopt a tacit or conniving attitude towards wrongdoings. This is a recent case that was judged in 2021. Taiji Company, a Taiji chemical company, was incorporated in Gansu province in 2017. They started all the construction, but ever since then, they never established, set up any environmental protection and sewage discharge treatment, nor did he receive any discharge license. So all the sewage, the pollution produced by the company was directly dumped in a very simple tank at the southwest corner of the company. Then the general manager instructs the plant director to dump it. Then the plant director arranged for an ordinary worker to dump it in the Gobi Desert, which is 1 kilometer away from the company. Very soon, this wrongdoing was discovered by the public and prosecuted in the People's Court. The final judgment is the company was deemed as committed the environmental crime, and both the general manager and the plant director was put into the prison for 3 years. But as to the legal representative, because during the incorporation process, the general manager borrowed the legal representative's identification card and registered him as a legal representative. Actually, the legal representative never participates in the management and the operation of the company, nor did he receive any dividends from the company. But most importantly, he knew nothing about these wrongdoings. So he was not committed, deemed as committed any charge. So what would be the consequences if a corporate executive is found violating the law? In terms of the administrative penalty under the work safety law, the liable executive might be imposed on a fine which is equal to 100% of his or her last year's annual income. Under the environmental law, he might be subject to detention of up to 15 days. In terms of the criminal law, he might be put in the prison of up to 15 years. But even if such liable person is not finally decided as violates the law, he might be subject to the enforcement measure during the investment period, like summons, restriction from leaving China. Given the potential serious consequences, what should the corporate executive do? So here are 3 tips for you. The first is, we think you need to get familiar with all the regulations that apply to your business and understand fully your specific role in order to manage the work safety and the environmental related law. And the second is, we think you need to demonstrate that you are actively thinking about how to control and managing all the risk that might exist in your business, your workplace. Last one is, I think, a very robust policy or internal rule should be put in place in order to ensure full compliance with the work safety and the environmental law. That's all.
Thanks, Yiming, for your brilliant introduction about the environmental law and the work safety. Now let me bring you to the world of the cybersecurity and data protection. As you all know that in the recent 2 years, especially last year, we have the 2 new laws, the Personal Information Protection Law and the Data Security Law. These 2 laws have been effective for a year, but don't forget that we already have cybersecurity law, which has been effective for 7 years to now. So firstly, to be clear, today in the topic of cybersecurity and data protection, I will only talk about the administrative punishment cases, the risks for the VVIP and VIPs of a company, because for civil and criminal liabilities, they need to analyze case by case. So today I will introduce this part in 4 aspects. Firstly, who are concerned? We need to know who need to pay attention to this aspect. Secondly, we need to know what are the red lines for a company to pay attention to. So I will introduce the key obligations under the 3 major laws. And thirdly, I will introduce when and how the VVIP and VIPs of a company will be affected in non-compliance of a company. And in the end, I will give you some personal recommendations on how to mitigate the risks in non-compliance. So firstly, let's take a look at who are concerned. For a company, we have VVIPs. They are both. They include the legal representative, the general manager, the chairman of the board of directors, or some CEO. However, as you know that for VVIPs, they might have a broad or vague understanding on compliance, but they much rely on the shoulder of the VIPs, the managers of different departments, to implement the compliance measures. So for VIPs, they can include the CTO, CIO, the head of IT, or now we have the Chief Information Security Officer. And don't forget that in practice, we already notified some cases where sales manager, purchase department manager can also be affected if they are found liable for misconduct of an enterprise. We will introduce this part in the following slides. So let's take a look at what are the key compliance obligations. So for the VVIP and especially the VIPs who are in charge of some departments, they need to know what are the red lines, violating of which will trigger personal liability for themselves. I think they could be, this part could be more interesting for companies who are in the technology industry. So firstly, if you know you have some background information of the Chinese cybersecurity law, I think you must heard the name of the MLPS, the Multi-Level Protection Scheme. Chinese authorities, I mean the Cyberspace Administration of China, they are frequently check, supervise the compliance level of a company by checking whether a company has implemented the MLPS, Multi-Level Protection Scheme. So in practice, especially in the recent years, we have the pandemic, the COVID situation, more and more companies, they rely on technology to work from home to keep their business continuity. So what if a company has some cyber incident or data breach? In these scenarios, companies and those VIPs need to show their company has some contingency plan, help them to manage this kind of situation. And for some critical information infrastructure operators, we call it CIOs. They normally in the very key industries, such as medical industry, banking, financial, pharmaceutical, or automotive, transportation, key industries, they need to pay attention to their purchase department, because for these CIOs, they need to face strict requirements on purchasing network product, network service, and their management of data. So the 5 aspects I listed are the key compliance obligations under the cybersecurity law. And you might find alert in the end of these slides. There's a bad news about cybersecurity law, because in the second half of this year, the competent authority, the Cyberspace Administration of China, they may amend the cybersecurity law in the future to increase the personal liability of the VVIPs or VIPs. The pecuniary fine may go up to 1 million RMB. This punishment, it's same in this personal information protection law. As you know that under the GDPR, the punishment of violating GDPR for companies can go up to 4% of the previous year's turnover. So in China, you can see the Chinese government, they really want to give a severe punishment on violations. So next part, we will take a look at what are the key compliance obligations under the data security law and personal information protection law. You can find that they share something in common. For data and personal information is part of data. For companies, they need to know what type of data they are controlling, they are transferring, they are receiving from their business partners. I have a case in point to be shared with you. It's about a Chinese IT company who provided, I don't know whether this company still exists now. This company provided consulting. It's not a scary story, it's a real story. You can check it online. It's about a Chinese IT company who providing consulting service or technical support for its client domestically and also for international clients. 2 years ago, this company was contacted by a foreign company asking for technical support regarding transportation data. This foreign client asked for transportation data related to Chinese high-speed railway nationwide, and they pay a lot. The margin rate was, I remember, it's 80% or 90%. So, and they want to pay it for a long term. So this company even consulted their in-house legal, and their in-house legal suggests that they don't do that because if they do that, the data was transferred to the other jurisdictions. You cannot control where the data will be used by the client. So in the end, the consequence is that the general manager of this company and the sales manager of this company, the two gentlemen were all arrested for providing national intelligence to a foreign company. So they face criminal liabilities. So in this case, you can see that sometimes you were thinking the data is a commercial data, it's a public data you can obtain in normal business operation. But in fact, those data can be important data, which is subject to security assessment by the authority. And in the case I just shared with you, the transportation data about the Chinese high-speed railway could be considered as critical data, which on no circumstances could be transferred to other jurisdictions. So the key point is to know the data you are sharing and you are receiving. As to the personal information protection law, I think you are super familiar with this topic because this topic has been discussed frequently during different seminars. For B2B type of companies, you need to pay attention to your internal processing of your employee data. And in the meantime, you also need to pay attention to the external personal information you collected or your employees collected in the business. And for cross-border data transfer, I think you heard some legal involvement in the second half of this year. In the coming days, personal information cross-border data transfer, including the internal employees and external consumers, business partners, those cross-border personal information transfer will be governed by the authority formally. Now the legal framework is quite clear. I will share another case about Chinese Uber, the Didi company. I think some of you might heard this story. It will lead me to the third part, when and how the VIP and VVIPs will be affected in violations. So firstly, when will VIP will be affected? According to the existing administrative punishment cases, we can see that I give you some comfort. Not all the violations will lead to personal liabilities for VIP or VVIPs. However, if your company is found non-compliant by the authority or investigated by the authority on site, don't worry, you still got a chance to avoid personal liability. This is the timing you need to consult professionals in-house and externally. Because if you can correct this non-compliance, I mean light violations, within the grace period given by the authority, I think in the end, if you have a very good attitude and you correct the light violation efficiently, I think in the end, you may only get a warning. However, if you fail to do so, in some of the cases, the VVIP or VIPs, they will all be affected. However, in light cases, the fine will not be so high, but I think you don't want to leave a record in your social credit individual profile. My colleague Colleen, she will introduce this part later. However, I will introduce the second story about the Chinese Uber Didi. I think you might heard that this company had been investigated by the Chinese authority for a year, and this company was found out severely violated many Chinese laws, among which include the Personal Information Protection Law. The president of this group and the general manager of this group, they were all imposed a fine amount to 1 million RMB respectively. And I think for Chinese young people or all the people, as long as we use this software, we all know this news because it's shocking news, the top one on the newspaper on that day. So you see that only in very severe violation will trigger severe personal liability for the VIP and VVIPs. So secondly, how will VIPs will be affected? As I mentioned, in some cases, they might receive a fine. The fine goes up to 1 million RMB. This is the maximum, and only in very severe cases. However, please note that in the law, the authority can also, in the same time, impose a prohibition from the relevant VIP or VVIP for the VIP from holding relevant position for a certain period of time. However, according to the public information, we haven't notified any existing cases, but we believe in the future there will be many, especially regarding cybersecurity and personal information. And then the last part is about social credit. As you know, I just mentioned that for corporate and individual, we all have a social credit. It will affect whether you can get a loan in the bank. So it's quite important to keep your social credit clean. So the last part is our recommendation. As I mentioned, that it's quite important to take compliance measures immediately. The first step is to know the gap, the status quo towards the compliance requirement. And the second step is to focus on the red lines, the key compliance obligations, because you cannot do everything at the same time. And the third step and the fourth one is to improve the awareness of the employees and the VIP and VVIPs. Because as you know that in China, we have the cybersecurity law for just 7 years, and the data security law and the personal information protection law, only 1 year. So compared to Europe, we have a long way to go. So it's quite important to have trainings for your employees. And the last part is to cooperate with in-house legal counsel and external professionals when you implement the compliance measures. And when you are found non-compliant, that's the really dangerous timing. You need to seek external help. So that's basically my part. Now I will give the floor to my colleague Yijun. She will introduce the tax part.
Okay, thanks, baby. So tax is always a scary topic because it is about money, and it's about the money owed to the state. And so basically, the tax non-compliance may trigger both administrative compulsory measures and criminal liabilities. So from the administrative perspective, so the first weapon of the tax authority is prohibiting the legal representative of taxpayer from leaving China. So if the company has fails to pay the outstanding taxes and late payment interest, and fails to provide a guarantee of equivalent amounts to the authorities, then authorities can launch the action together with the border control police to prevent the legal representative from leaving the territory if the unpaid tax reaches the threshold of 200,000 RMB. So this measure for the authorities is not new. Actually, it was established by a very old regulation of 1996. And this regulation also specified that if there's a change of legal representative, then the new person will be subject to the restriction measure. Also, if the legal representative is based abroad, then the main in charge person who is based in China will be subject to this restriction. It could be the case of general manager or managing director, who is based in China at that time. The second weapon, tax credit rating. So China has started to implement the tax credit rating system since 2014. So as you know, now each company is given a tax grade from A to D. So A is good, D is bad, and a company will be graded as D taxpayer, either under the so-called scoring system, meaning that we start from 100 points, and then each time there's a tax non-compliance, then the company will lose some points. If at the end of the year the company gets less than 40 points, then it will be given a D grade, or the company will also be directly classified as D grade taxpayer. In some cases, listed here on my slides. So I did not put the full list, but basically here we're talking about the tax violation, so which is different from the simple mere omission of tax filing or tax payment. For example, the tax evasion reaching a certain threshold in terms of amount and percentage, also providing fake documents in order to enjoy the preferential tax treatment, etc. So we can consider the D tax grade as a kind of a gray list. And in case of more serious violation, there will also be the blacklist. We'll get back to the blacklist later. So for D grade taxpayer, so firstly, the information will be shared to different authorities. So these authorities could suggest some restrictions in terms of bank loan financing, import, export, and public procurement, etc. So secondly, the public disclosure. So far in China, now only the blacklisted taxpayer are disclosed to the public. But for mere D grade taxpayer, it is not yet in place, but it is something under planning by the authority as provided by the regulation. And also, if you are the legal representative or actual responsible person of a D grade taxpayer, and then your other entities, companies that you represent or you operate will also be classified as a D grade taxpayer. So we're talking about the gray list. So now we come to the blacklist. In case of serious tax violations with the evaded tax amount, which is higher, for example, the tax evasion reaching more than 1 million RMB. So here I would like to draw your attention to the fact that this criteria, actually the newest version of the criteria of blacklist, which was introduced early this year. So as compared to the previous versions, the legislator, as you can see, has added the liabilities of the third parties, as I highlight here. So, for example, the entities or persons who illegally provide bank accounts and invoices or other convenience to taxpayers. So here, other convenience, it is a very broad concept notion, so it could be everything. And also the tax agent representative that violated the tax law and causes the underpayment of tax by taxpayers for more than 1 million, then these third parties will also bear liabilities and be blacklisted. So this is a major change compared to before. What are consequences for blacklisted taxpayers? So first, the public disclosure. So for blacklisted taxpayer, the disclosure is almost automatic. So with the name of the legal representative and or the actual responsible person. And then the company and the legal representative as well the finance in charge person will be subject to the joint punishment by more than 20 authorities. So for individuals, as you can see, there are a list of punishment measures, so which are basically the same as the one introduced by my colleagues before. A prohibition from leaving China and a restriction on high consumption. So here we know that the prohibition from leaving China, it is not that very clear whether it is this measure is always limited to the legal representative, so as provided for by the 1996 regulation, or it can be extended to other senior managers. So if we read the text of law, it's not very clear. But based on the, I think, the spirit of this joint punishment regulation, and also the interpretation of some local tax authorities, so it is possible that it could be extended to at least, for example, the CFO or chief accountant. But so far, we did not really identify many cases for CFO or chief accountant. So in I would say 95% cases we saw it's always about the legal representative. Okay. Yeah. Then if a tax violation constitutes a crime, as mentioned by my colleagues, so the person in a corporate crime, the person directly in charge and or the person directly liable for the wrongdoing will be subject to the personal punishment. But in criminal affairs, the court usually takes a much more prudent approach to determine which person is liable. And taking an example of a tax evasion crime, actually there's several tax-related crimes. So tax evasion, if the evaded amount is huge, meaning that more than 100,000 RMB, then up to 7 years of imprisonment. And if the amount is very huge, then 7 years. Then on the criminal law, as a relief measure, so there will be no criminal liabilities if the company can make up the tax payment on time after notification by tax authority. So the criminal liability could be waived in that case, unless the company commits the violation and the tax crimes repeatedly within 5 years. And so at the end, I want to share with you some trends of Chinese tax authorities' actions in recent years. So firstly, we see more and more cases of in which the tax authorities prevent the legal representative of taxpayers from leaving China. Just to give you some numbers, the relevant regulation, which was especially almost 30 years ago, actually this measure was not really effective, was not really applied before. For example, in Beijing, it is only in 2014 that Beijing Tax Authority took this action for the first time to catch the legal representative for a Chinese company at the airport. It was the first time in Beijing. However, from 2014 to 2019, so over 5 years, according to official statistics, there were around 6,000 cases nationwide. So we don't have the numbers of the last 2 years, but it should be huge. And secondly, we also see the ever aggressive measures taken by the tax authority recently. For example, you might have heard various tax audit cases on the movie stars and influencers in China recently. And we can see that the tax authority now systematically actually try to apply the highest range of penalty as possible. So without giving any tolerance, so which was not the case before, because before this kind of penalty could always be negotiated, sometimes waived. And also it seems that the tax authority tend to adopt the strictest interpretation of the tax law when it is not very clear. For example, there are some arrangements, very complex arrangements. It is even difficult for us to say whether this arrangement is a tax avoidance or a tax evasion. actually there's a difference between two things. So tax avoidance means that you use legal means, you use the legal ways, but just you set up arrangement to for the purpose of not paying tax or paying less tax. Tax evasion is more straightforward. You don't declare your income or you declare less. So for tax avoidance, there are no huge penalties, there are no criminal liabilities, but for tax evasion, yes. But sometimes the line between two things is not very clear. But we can see in the recent audit case, especially on movie stars, the Chinese tax authority automatically considered and held that the arrangement constitute tax evasion, and they imposed a very high penalty. So we don't have all details of these cases, but I think that there could be some debates and there's some thoughts about the qualification made by the Chinese tax authority on this arrangement. So finally, as I just mentioned, there's a trend that they want to include the third parties liabilities. So the people who provide convenience to taxpayer in tax evasion, or the tax professionals who provide illegal assistance to taxpayer. So I think now the tax official and the individuals will be much more prudent in suggesting some aggressive tax optimization schemes to the taxpayers, to individuals. The last part suggestion. So first, I would say it is now time to stop the idea of act like Chinese or do it in Chinese way. So there's no Chinese way, but there's a Chinese law. And also secondly, seek professional advice when you have doubt on the accounting or tax matter. Also, you must regularly follow up the updates of the regulation to be sure that you are always compliant. In terms of internal management, so in order to protect yourself, so properly record the decision-making process and do not sign anything before checking whether it is illegal. And the last one, to enjoy the relief under administrative and criminal laws. The company is suggested to settle unpaid taxes promptly after being notified by tax authorities. If you don't agree with the tax officer, then go ahead and initiate the active communication with the tax officer, just to avoid escaping or hiding yourself facing their challenges. So basically that's my part, and I will pass my microphone to my.
Thank you, Yijun. So I'm the last one, and what I'm going to talk about is at the very end of a legal proceeding. It's what would happen if you don't enforce a court judgment. So this is a scenario where your company, unfortunately, gets sued either by a business partner, your supplier, or whatever, they want to sue you, or an employee for a labor dispute, they bring it to the court and you lost. And then you refuse to pay. You're saying, okay, I think this is wrong. I think the court made a mistake, or simply because I don't have money to pay. And what would happen, apart from the company, but personally to the company's executives if they refuse to pay? And this is also the case counterpart if you actually have a case that's winning. I have a court judgment saying, okay, you have to pay me 1 million, and you don't. What can I do to the executives of that party, of that company? So 3 types of consequence: restriction on the high-level consumption, inclusion on the list of dishonest individuals, and restriction on departure from China. What do they mean? Restriction on high-level consumption. What are high-level consumptions? We were talking about the other day. It's quite a bit like lockdown. So no flights, no high-speed railway trains, no good restaurants, no good hotels, no nightclubs, no golf balls. I don't know if any of you play golf, but no golf is specified in the law. You can't buy railway property. You can't rent a good office building. Your kids can't go to private schools, but I think that's more for the Chinese nationals. And there are other unnecessary consumptions that are prohibited. The second one, inclusion on the list of dishonest individuals. if you are listed in the dishonest individual list, automatically the high-level consumption restriction applies to you. And apart from that, because they consider your credit is basically bankrupt, so you can't get a loan from the bank, you can't get a credit card, and you will be prohibited to hold some high-level management offices in the companies. And that's the personal part. Of course, on the company part, they have restrictions on you participate in the bidding process with some nation stake companies. And the last one, restriction on departure from China. That's quite clear or obvious. You're basically grounded in China. And I think for foreign passport holders, it's quite, you will consider to avoid that. And so who will face it and when? So as I said, if you have a judgment against your company, legal representatives, key person in charge, direct accountable person, and actual controlling person, those are the people who will automatically be listed to have high-level consumption restriction. They will not automatically go onto the dishonest individual, but it's very close, because if you break the high-level consumption restriction, you will then go to the dishonest individuals. And you might think this is quite far from our life, but actually up to 2022, there are more than 15 million people that has been listed in that list. If you think about it, it's actually 1/4 of the French population. So that's quite a lot. And also another thing is like they are kind of related, because although, for example, the restriction on departure from China, you have to apply it separately. But as you remember, if you can't consume the high-level consumption, you are not allowed to take a flight. And that can mean, like, you know, how can you leave China if you can't take a flight? You can walk, but that's not the majority. So yeah, we've actually had a case in 2016. It's quite quite hilarious one. This guy, when he left China, he went to actually South Pole to go on traveling to see the cute penguins and stuff. And when he left China, he's not on the list. And then his company had problems. He then moved on to the high-level consumption restriction list. And so while he's in North South Pole and he tried to book a flight back to China, he found himself unable to. So he's stuck there and unable to come back. Well, it's actually sounds quite scary. So how to solve it? The best way, of course, to enforce the judgment, to make the payment, to don't fight at this stage. Of course, there are maybe you have specific reasons why you don't want to. There might be ways to avoid going onto this list. You might be able to provide a guarantee. You might negotiate with the other party to say, okay, can you give me the consent? And in the case of legal representatives, sometimes, as Amy just said, sometimes the legal representatives actually don't know what's going on in the company. I just borrowed my ID card and then suddenly I can't buy a ticket. There might be ways. For example, you can sue in the court to change the legal representative, and if you meet certain requirement, you might sue to dissolve the company. If the company needs a requirement to go bankruptcy, you might bring that proceedings. But these are subject to very strict requirements, and if you find yourself unfortunately gets to that point, go seek legal advice. Yeah. So as we can see. If you actually get a court judgment that's in favor of you, the Chinese government or the Chinese court do have ways to compel you to comply with it. And that's it for my part. So in general, we can see that for the executive liabilities, it's well regulated in China. We're not here to scare you. We hope you stay. We hope you grow, and we hope you thrive in this difficult market. But it's good to keep informed always. And I think I'll now pass this to the floor if you have any questions.
Thank you very much, all of you. I'm curious on the restriction on the high-level consumption, because concretely, does it mean that, let's say, a Louis Vuitton store, they have access to the list of people who are prevented to buy these kind of products? Or concretely, how can it be applied?
Yes. Yeah, for example, for the flight tickets, it's you can check it. It's actually open, and especially for domestic flight company, you are actually unable to purchase it. It's open. And sometimes, like for example, for the restriction on kids going to private schools, that one, like, it's not enforced nationwide. But for example, in Guangzhou, they will tell those private schools, well, to check the parents' credit situation. If they are on the list, and maybe their kids can only go to public schools. Yeah, so they have ways to do that.
And another question, in the list of all the potential liable people, is there the supervisor? Because I never saw...
Supervisors not listed directly, as you said.
Just for the general rule part, we talked about the loyalty duty and diligence duty that also apply to supervisor. But for the administrative liability and criminal liability, because we're talking about the liable person in like decision making power regarding the non-compliance. But supervisors, how can I say, has a function in the company is kind of remote. Regarding to those decision-making power. But for the civil liability, yes, those duties still apply to supervisor. Yeah.
Yeah, thanks again, all of you, for the introduction. I have a specific question. If the legal representative is not physically in China, but abroad, I heard some of you speak about that, but basically, are they liable although they are abroad, or is the liability goes down to whoever is there, general manager or the people below, or how does it work? Be it full-time abroad, let's say, well, it could be the CEO of the group back in Europe, or it could be like away temporarily, which nowadays might be months or years. Many of you, actually.
Well, I will give explanation on those general rules, and then if any other specific topic has anything to add on. So as I mentioned that according to Chinese company law, the legal representative is can only be the chairman of the board, or the executive director or the general manager. So it's not anyone else can be the legal representative. So basically, those general rules regarding the liability still apply to legal representative, even though he's not in China. And yeah, and also like I think like if he has been like in abroad, and then for example, if he's the general manager, but general manager is supposed to manage the company, and then we go back to the loyalty duty and the diligence duty. So so that general rule still applies. But for the administrative liability and criminal liability, so we determine whether he's the liable person. Then we still go to the testing regarding whether he's how much he has been involved in those illegal activities of the company, and how much decision making power that he possesses. So as I think like Amy mentioned an example in the work safety and environmental case. So the legal representative actually, even though he's the general manager of the company, but he can prove, so I think the process goes like this way. When the government found out there's a non-compliance of the company, they probably go to the legal representative by default. So assuming that he has something to do with this, and then the burden goes to the legal representative. He can prove like, okay, actually I have nothing to do with this, and I'm not in the decision making process, and then he can get rid of this accusation. So basically, the game goes like this way. Yeah. And
Because based on our experience, some client has faced this issue in the past. Our practical advice towards such kind of situation is stay where you are, meaning you don't enter the territory of China, because China can introduce that person who currently in the foreign country back to China. but according to the law and the practice, it's very, very lengthy and very complex. So in practice, it doesn't work. So in such situation, our advice is just stay in France, enjoying the non-lockdown life.
I have something to add because for personal information protection law, as I mentioned that this law is quite new, there's a special rule under this law because according to my colleague, normally if a company is found non-compliant, the liable person can be the legal representative or the general manager will be held liable for severe violations. However, under the personal information protection law, there is a reverse of the burden of proof. It means that if a personal information breach or data breach is found in a company, the company need to prove that it has done the necessary mandatory measures in organizational aspects and technical aspects to prove that the company is compliant. Otherwise, this company need to be liable for this violation, because this law is quite special because this kind of reverse of burden of proof is not so common under Chinese laws. So I want to emphasize this part. Anyone to add?
I think it's a very practical question. So this is why we talked about the internal compliance system. This is why we talked about the gift declaration rules earlier. Like obviously, in real life, like companies tend to extend their goodwill or to try to build a relationship with the other company by sending some small gifts. However, the gifts can be of no value other than just nominal. So just bear in mind the value of these gifts or these products. It can be just nominal. Normally, if it's just like 100, it can be okay. But if it's of some significant value, then like chances are like the company will just get into trouble. However, when we analyze these problems, we need to analyze it in different localities, and we need to dig into the certain areas, certain markets to give you a more concrete answer. But I think maybe my colleagues they have more to add on if.
So usually, if the gift is below 200 RMB, it's sure in most situations safe. But we understand that a lot of doctors are Communist Party members. So according to Communist Party's constitution, they cannot receive the gift in the value above 15 RMB. 50. Otherwise, if they are the member, CPC member, they will be punished. So it's better that, like my colleague said, it should be very nominal. Maybe the question is not for me, but I think I can answer in a general way. Actually, this criminal, this principle of determining who's a liable person, which is basically similar for various fields, not only for tax, but for tax, for example, the criminal law does not define the scope of this directly in charge person and the directly liable person, but according to interpretation of the Supreme Court and on the financial criminal affairs, it should be someone who plays, so firstly has a decision-making power and also who plays a role of instructing and organizing and planning and implementing the wrongdoing. So in financial criminal affairs, so there's some criteria. So it's the mere fact that you are registered as a legal representative on the paper with the AMR authorities is not sufficient itself to establish your criminal liabilities. So that's for financial criminal affairs, but I don't know if you have ideas for other fields. Same for the criminal liability under environmental and work safety law. So as long as the executive has the decision-making power, or just cannot stop the wrongdoing, he will be liable. So same policy, I think, for all the regulations.
Okay, another question online. Okay, I will repeat what we just answered because maybe they didn't hear it online. So we just answered the question regarding the criminal liability for tax compliance needs a proof of active involvement, and if it's a case also for the other kind of compliance. The new question is more generally, could you share a suggestion on mitigate the personal liability? Delegation of power insurance, or delegation DO insurance, delegation of power as proof of shifting the responsibility.
Because the delegation powers is one question often asked by our client, but unfortunately in China we don't have a system of delegation of powers like in France. So in China, the delegator is like the principal, the delegatee is like the agent. So their relationship is more like an agency relationship. So the principal should bear the legal effects of the agent's acts. That means the delegator should bear all the consequences of the person to whom he gives the delegation of powers. But however, that does not mean that the delegation of powers is useless. In practice, if it is well prepared and established, it can still reduce the liability of the delegator to some extent. So for example, as we said, because it can protect the delegator, for example, from the potential claim from the company itself. If the company said that the delegator does not fulfill its diligence duties, in this case, to protect the delegator, the best way is to have such delegation of powers approved by the shareholders, approved by the board directors, and it's better to clearly mention in the delegation of powers that once these powers are delegated to another individual, the delegator himself will no longer be responsible for these duties. Then there's a way to protect against the company's liability, company's claims. And for the for the administrative liabilities, the delegation powers have no such use because the administrative liabilities is more linked to the title of the person in the company. And for the criminal liabilities, the delegation of powers can be used for, but it is not sufficient. You need to have other evidence to show that, for example, my powers have been delegated, there is a written document, and myself is not aware of this crime, and I did not participate to the decision making. I have not even signed any document, and because I'm not aware of it, so I can't stop it. So all this evidence together can mitigate the liability of the delegator. So in conclusion, in China, the delegation powers cannot exempt totally the liability of the delegator, but it is still recommended because it can reduce the risk and liability of this person, and we often help our clients to establish such kind of documents. And other recommendations include, for example, for the company itself, we should establish some internal rules. For example, how to make decision making, how to keep the company jobs, the business license, which duty is attributed to each department manager. So when there's a misconduct, we can trace easily the responsible person in a crime, for example. And another tip is to have written record of each decision making, because I know that a lot of companies, our clients, will only have some board resolution just to approve the accounts at the year of the end, or if they really have a need to submit to the authorities, and they don't pay attention to other decision making in the daily life. So our suggestion is that you need to, for each topic, to have some discussions, and the person who don't agree with this decision should expressly mention and to written in some document that I'm against this decision. So this is a way to protect himself. Thank you.
Any other questions? Great. Andrea, something to add? Oh, okay. Yes, exactly. Thank you very much. Thank you everyone for attending this very